You don't like the whole situation?
No,
Hang on, don't overtalk me. I'm not playing games and I'm not going to accept the disrespect. Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, man, I wouldn't mind.
I feel like I might because I'm not understanding. I've been doing this for 30 years. I appreciate your family being here and I appreciate the support and I appreciate this letter, but it's all ridiculous when you look at your criminal history. Zero tolerance means you don't get another opportunity. Okay? Why'd you just look at her like that right in front of me? Don't, no ma'am. No one is against him today. Don't say another word or you're going to end up in trouble. No one's against you today.
Subject matter jurisdiction.
That's overruled.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Mr. Rayleigh, in cause number 25 DCCR 1482, you're charged with the state jail felony offense of engaging in organized criminal activity. And that's from September 28th of 2025. And how do you plead to that charge?
Yes, guilty, right? Sounds things. Right.
So did you do this?
Did you do it or did you not do it? If you did it, it's guilty. If you didn't do it, then it's not guilty and we have a trial.
I mean, I committed a misdemeanor. I know that.
All right, I'm going to hold the case. Y'all go talk.
Yeah.
Ask any questions you have of Mr. Rojas. Listen carefully to his answers. He's telling you what the law is, and then we'll decide. You can decide if you want to take the deal or not, or if you want to go to trial. How do you plead?
Guilty.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
So, Mr. Rayleigh, your unwillingness today at first to take responsibility gives me some concern.
Yeah.
What you guys were doing that day was absolutely ridiculous.
Yes.
And somebody could have been seriously hurt.
Yes, ma'am.
A paintball can cause all kinds of serious bodily injury.
Yes, ma'am. And I told Mr. Rojas I'd be willing to do anything civil matter with the victim. You know, I'm not a just horrible person. I'm
No, I mean, y'all, it was ridiculous and stupid. And you're lucky you're not here for an aggravated assault with a deadly weapon by shooting an eye or shooting somebody in the head in the wrong place.
Yes, ma'am. 3
people were shot just driving. You're lucky that y'all didn't get shot because somebody didn't think it was a real gun. And that's what people are doing everywhere now is shooting people. So you're out there with a paintball gun, but you in turn could end up shot. So I just want to make sure you understand that giving me an opportunity to review this gives me some concern. You need to take advantage of this opportunity. You're very young. There's no reason for you not to be able to be successful and make some better decisions. But you need to understand the importance of this as felony court. Doesn't have anything to do with civil court. Doesn't have anything to do with paying them back. It has to do with you doing your probation right. And if you don't, you go to prison. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing just so I can get a little more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? See you back at sentencing. And Mr. Rayleigh, you were here just last week or the week before, and you pled guilty to an offense, and you were told to go to the probation department and do a pre-sentence report. And I've gotten a memo from them that has some unfortunate information in here about how you acted while you were there and visiting with them.
Yes, ma'am. I was over the phone when the lady was arguing and stuff. I just wanted the information on when I was supposed to meet the dudes. That was it. And
That's not how this reads.
they
They were so frustrated with you that they said they will not do a pre-sentence report while you're on bond. So do you know what that means?
my bond had to be paid off.
No, that means I'm going to revoke your bond
Okay.
and you're going to go to jail.
Okay.
And then they're going to come to the jail and do the pre-sentence report. And you're going to be respectful to them. Or I don't have to go along with this plea agreement.
Yes, ma'am.
So listen, it's time to get a whole different attitude about all of this. I understand. I remember now when you were here, you don't like the whole situation.
No,
Hang on, don't overtalk me because that's going to show me what you're doing to them. Okay. Now it's just the time to listen.
Yes, ma'am.
All right. And just do what you're told. There's not an excuse for what you did. That's not, you didn't just try to ask for some information. Okay, they wouldn't have sent this. They're very, very patient.
I just want to let you know I got a whole different view about it on the whole situation now too. I just got to meet my son for the first time on Friday, so
Well, this is very unfortunate.
Yeah.
So you'll, but here's the thing, there's no reason for you to still not get this probation, but I don't have a choice now but to get this pre-sentence report done. So I'm going to, hang on, I'm going to revoke your bond in your case at this time. You're going to go with the bailiff. Probation's going to come to the jail. They're going to do this pre-sentence report, probably not today.
do I get a new bond today?
I'm not giving you a bond because you couldn't act right while you were on bond, which shows me that you see where I'm.
Yeah,
the
can
problem-
can we just like revoke the deal and take it to trial? I can't afford to go to jail, please.
You're going to jail regardless. Why?
Yeah, it's not
Because,
fine.
do you want me to read the memo?
The whole thing, yeah, can we play the voice recordings of the phone call in here today too, if that's the case? Because if you're just gonna believe what she says, then I believe I have the right to fight on behalf of what I have to say, and we need to be able to play those phone recordings.
You're gonna
before
go
today.
do that, you're gonna go do that
Of
pre-sentence
course, we're not gonna play
report,
phone recordings today.
and you're gonna go and hopefully be respectful and hopefully get this probation and not ruin your life over this.
Oh,
This is
what's
very-
the longest you think I'll be in
It's
there?
a very temporary situation. Mr. Rojas can come back and talk to you. I'm revoking your bond at this time. I find it's in the best interest until sentencing that there not be a bond. You can go back with the bailiff. Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? There, it's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
Either there's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Guilty.
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I plead no content because he never even went over the indictment with me.
Yeah.
I find that hard to believe. So here's
To
the thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
Here's a picture
In both
of here.
Yeah.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment. after
Sir,
I-
the
That's why
allegation,
I'm pleading no contest.
I'm not going to
I
allow,
find guilty. It's fine.
here's the thing, I don't have to accept any plea agreement.
Yes, ma'am.
Okay, so you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual, you're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not gonna accept the disrespect. If you want me to follow this agreement and go along with the plea agreement and you can go on, do your time and be done with it, then we can get that done. But you're not gonna show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea
If-
agreement.
If you go to trial, listen to me. If
Yeah,
you go to
but-
trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. He's saying assault family violence. The invading arrest is I
Listen,
plead guilty.
It's evading arrest or detention
But
with
what
the
are you
use.
looking at? I'm saying
I'm
Look,
looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you
Right.
you were
Hold on,
convicted of
just
something
Mr.
else. Okay.
You've probably already tried. Let me take care of it this way.
I-
Place that
okay.
in front of your client, please. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020.
Yeah.
How do you plead to
Yeah.
that charge?
I just pled no content. She didn't want to accept
She-
no content.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not gonna plead no contest.
Guilty or not, you plead guilty or not guilty.
So if I'm telling you no content, what is that?
It's nothing and it's nothing. You're not allowed, I can take a plea of no contest or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty,
I'm saying.
period. I'm
That's
about
saying
to
that
set
I'm
your
not-
case for
that's saying
trial.
that I'm not, that's basically saying that I'm
We're not going to argue the
guilty, I'm
law.
not, or I'm guilty.
We're not arguing
That's
the law.
basically just saying that
It
I
doesn't-
state that.
I'm not going to
Go
argue
ahead,
the law
fine,
with
no
you.
guilty. Just sign, go ahead.
I
Put it
don't,
as guilty. Go ahead. That's what y'all want anyway. That's fine.
listen.
I'm cool, ma'am. Just go ahead. and
Well,
get
you're
the
not,
guilty.
you're really not being cool and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the guilty.
Nothing here.
Plead guilty. There you
Okay,
go.
so you plead guilty to evading arrest or detention
Yes,
with the
ma'am.
use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence, December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same
That's
case
okay.
as far as
Look-
evading arrest, ma'am. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And that's,
that.
listen, so Mr.
That's
Campbell,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you needed some help, ma'am, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay. So did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
Nope.
Okay, so in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
Pleading no content, but guilty now.
So are you pleading guilty to this charge?
Yeah. That's
Okay.
fortunate.
And did anybody force you to plead guilty in cause number 2239050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's go. So no.
Okay. All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, pay attention to me for a second, please.
Oh, foul, please. I ain't drinking,
Mr. Campbell, you ready?
Yeah.
Doesn't have to be that difficult. Just get in, get your deal and get out. You're making this way more difficult than it has to be. Finds you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. Find sufficient evidence to find you guilty and at this time finds you guilty of tampering with physical evidence. Sentence you in accordance with your agreement to a term of 18 years in the institutional division of the Texas Department of Corrections. These two cases will run concurrently, which means together at the same time and concurrently with any other sentence that you're currently serving. You can go back with the bailiff.
So do I get my papers for my time, sir?
Go back with the bailiff.
Is you gonna bring me my papers for my time,
They
sir?
have it in the jail.
Excuse me?
No, they have it at the jail. No.
You didn't tell me.
Well, he wasn't that bad.
I mean, this one might be difficult and Judge, this one's really gonna
He-
push you over the edge difficult.
This move.
Okay, you're Floyd Torren. Mr. Torren was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle also enhanced to a second degree. And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torren's mental health as well as some physical issues. And one letter as well of support.
Judge, Mr. Torren has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
Mr. Torren, in 2019, you received a 15-year sentence. I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you as a grown man have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. Your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used. I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County. So that being said, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property. Find that prior conviction true, or the prior convictions true in that case. Sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. Find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. Good morning. Are you Camden Jackson? So in cause number 25 DCCR 0114, have a motion to revoke your unadjudicated probation. Shows that you were placed on probation August 5th of 2025 for the offense of engaging in organized criminal activity, and that was a 7-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to conduct yourself in a courteous and professional manner by disrespecting a female correctional officer by showing her a video that was lewd and in nature. Is that true or not true?
True.
Okay. Count 2 alleges, count 2 is really the same. Okay. All right. So did you enter your plea of true to count 1 freely and voluntarily? And did you plead true because that's actually true? All right. So I'm going to find count 1 true, find that you entered that plea freely and voluntarily, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. You are still ordered as a condition of the probation to enter and successfully complete the ISF program. When you're out, you will be on the mental health caseload so that you can get whatever help you need with medication, counseling, whatever it is. Once you get through that, you'll be on the high-medium caseload, which also means you're just going to have to be you're going to go more often. Probation's going to have more things to help you. It's not meant to be mean or make you go more than other people, but with what you're showing so far, you need this extra help. Okay, so if you do all of that, you're still on a deferred probation. You're still not a convicted felon. Today, just based on what I told you before about not getting in trouble, I could easily send you to prison for up to 20 years, just like that. And I understand that there's some behavioral issues going on, but I don't think any of those behavioral issues had anything to do with what you did to that correctional officer, okay? The cutting up, maybe the not being quiet, the fighting, all that stuff, maybe there's some issues. But that was a conscious decision that doesn't have anything to do with any other type of mental illness or help that you need to go and show her that. It was just being stupid, right? So if you make a choice, that's a choice. That's not something that we're going to blame on anything else. I understand some of the other write-ups. That one, I don't buy that has anything to do with that, right? So if you do anything like that, again, and you get in trouble, now that everything's lined out and you haven't been getting in trouble, if you do, before you go to ISF, we will not be having this conversation again, okay? Same rule applies. It is a condition now of your probation that you not receive an incident report. If you do, we're back in here, and I don't care what anybody says. You're going to end up in prison. You've got family. Nobody wants this to happen, but it's 100% up to you at this point, okay? If you get to ISF and you don't follow the rules in ISF and get in trouble there, same thing. That's a condition of your probation, is that you act right in ISF as well, okay? All right, so anything else?
0 tolerance.
And you'll be on 0 tolerance, which means really everybody should be on 0 tolerance when they're on probation. But when you're actually on what we call 0 tolerance, it means you cannot make any mistakes. You're being given a huge opportunity to change your life, make better decisions. And it's just going to be up to you to do that. And if you don't, it's not going to be, well, this is a one-time mess up, give me another opportunity. 0 tolerance means you don't get another opportunity, okay? Why'd you just look at her like that right in front of me? Don't, no ma'am. No one is against him today. Don't say another word or you're going to end up in trouble. No one's against you today. They're saving you from going to prison today, because that's what I was probably going to do. Because I gave you a specific instruction and you disregarded that instruction. And I don't think it has anything to do with mental illness that you're showing ladies videos that are inappropriate in the jail. Nobody made you do that. She didn't make you do that. I didn't make you do that. Do you understand? This is personal responsibility. It's time for you to take personal responsibility. And it's time for you to make him take personal responsibility and quit blaming other people for what he's doing.
I'm not blaming her.
That's what just I heard. So just hang on. Don't talk anymore. It's not going to help anything. You're receiving a huge chance today. And it's because of probation that you're getting that opportunity. Okay? So you remember that. It's because of them that you're getting this opportunity. Okay? Go back with the bailiff. Good morning, sir. Are you John Jones?
Yes, ma'am.
In cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder, and that's from April 28th of 2025. And how do you plead to that charge?
Guilty.
So you're charged in 24 DCCR 2431 with the state jail felony offense of unauthorized use of a vehicle. And that's from October 15th of 2024. And how do you plead to that charge?
Guilty.
And then finally, in cause number 25 BCCR 1352, you're charged with the first degree felony offense of aggravated robbery from September 18th of 2024. And how do you plead to that charge?
Guilty.
Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. These 3 cases will run concurrently, which means together at the same time. Now, let me tell you one more thing, Mr. Jones. You're still going to be in our jail for a limited time before they transfer you to TDC. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. But honestly, we're ready to get you out of our jail because you've been such a menace to everyone out there with what you're doing. And let me tell you, when you get to TDC, you think you're funny, you're young, you're not going to get away with what you're getting away with here in TDC. There's some bigger, badder, worse people than you there. And also, if you think you're going to make parole by acting how you've been acting, you're not. I would bet money today that you're going to be in our prisons for 35 years because you don't know how to behave. Prove me wrong, and that would be great if you figure it out and start learning how to mature and act like a normal human being like the rest of us. But my money is on you not doing that. So I wish you'd prove me wrong, because everybody that has to deal with you, they're just doing their job and you're putting them through all that. Go back with the bailiff. Good morning. Are you Kaden
Yes.
Fontinet? And this is 25 DCCR 1759. Mr. Fontinet was previously in court, entered a plea of guilty to the first-degree felony offense of aggravated robbery. It was an unagreed plea.
Yeah, I'll be brief. Whether it's the Pine Club Apartments or Rogers Park or a Speedy Mart, you've seen this, and we've seen this in this community all too often. I'm preaching to the choir, Judge. Prayer vigils and advisory committees, all that stuff's fine, but you judge where the rubber meets the road. You are that person that can protect the community from somebody like this defendant. You are that person that can either let him walk out of this courtroom on probation with a piece of paper with conditions and promises that he won't resort to this kind of violence that you saw on that video, or you can ensure that the community is safe by putting him behind steel bars, concrete wall, and razor wire fence. Judge, I'm just asking, I'm not in the habit of begging, but on behalf of this community, I'm begging that you send this defendant to prison. The message that needs to be sent to this defendant and his circle of friends and anybody who would want to be like this defendant is that if you pick up a gun with the intent to commit violence, you're gonna pick up a 15, 20, 25-year prison sentence, Judge. And I'm just asking that you do this on behalf of people who live at the Pine Club Apartments, who just want to live in peace, people who want to go take a walk at Rogers Park and not be robbed, and somebody that wants to stop at a Speedy Mart convenience store and pick up some snacks without becoming a victim of a robbery. That's all I have, Judge.
So, Mr. Fontenette, there was a time some years ago that there really wasn't even a question. Everyone, state's attorneys were recommending youthful offenders, probation. Let's give everybody an opportunity. And things have just changed in such an incredibly dangerous way with young people doing what I just saw you do on that screen. I cannot imagine the fear that that person had that was working in that store, that he now has, just trying to go to work, make a living, and go home. And he has 3 people come in and not just grab a little quick something and run out, but terrorize him for quite some time. Pulling him around, yanking him around, putting guns in his face, all 3 of you. I also, in addition to the PSI, get jail incident reports. And you apparently like to fight and jump people, which is what's been happening in the jail. So it makes it very difficult for me to go, oh, this is somebody that's going to get out and behave, who can follow the rules, because you can't even follow the rules in jail. The pre-sentence report shows that you're a high risk level, which tells me that after they've looked at everything, that you don't have, unfortunately, a good likelihood of being successful if I were to put you on probation. And Mr. Coleman's right. We're tired of it. And there's got to be something done. So in cause number 25, DCCR 1759, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. And at this time, I'm going to find you guilty of aggravated robbery. I'm going to sentence you to a term of 25 years in the institutional division.
Hey. Go.
Come on, Mom. Here. I'm going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Mr. Fontinet, I understand that this is harsh, and I know you believe this is harsh, but I think this is necessary. I hope that you go and you make things right. You can get out of prison. You're still going to be young, and you can make your life better. That's going to be up to you, okay? You can go back with the bailiff. Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry, speak up so I can
Here
hear you.
today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity, Nasir Brown.
At some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative. That's it.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay. And so, Mr. Brown, this is, nope, listen, this is your initial appearance and you have two cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very
And
patient.
at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
Is this what I'm saying?
Speak up so I can,
Up and down.
it's been up and down.
Yes.
Okay, so here's what I'm gonna do, Mr. Brown, is I'm just like everyone else, I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry,
Overstand.
say it
They
again.
overstand.
You overstand?
Yes.
Okay, what does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. Are you Nasir Brown?
Party intervener.
I'm
I
sorry.
think we were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the cop. I do have.
Take the glasses off. I need to see your eyes, please.
These are my prescription
That's
glasses.
okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
Wasn't able to get them.
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him high. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt. Okay. Did you go see Mr. Kimmler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is falling age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started an exam.
Don't make me lay hands on you,
Why would you lay hands on me?
because you're not doing what I'm telling you, now go. She
Mr.
tells
Brady,
that she go
you
back.
need to go back with the bailiff. There's right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you, I told you I was gonna put hands on you.